Welcome to the Benefits Executive Roundtable, hosted by Dorothy Cociu, President of Advanced Benefit Consulting. Dorothy is a nationally recognized benefits and compliance consultant and group health broker. Here, you will watch and listen to industry experts who will break down the latest trends in employee benefits, healthcare reform, state and federal legislative and regulatory activities, all designed to empower executive decisions. We are proud to bring to you all new for Season 6 video podcasts. We hope that you enjoy your new video podcast format, and please forgive any audio or video imperfections. Thank you for viewing and listening.
Welcome to the Benefits Executive Roundtable. I'm your host, Dorothy Cociu, President of Advanced Benefit Consulting, and I want to say that I'm so excited. This is Season 6, which is our first season of video podcast. So this has been quite a revelation for me because I'm not a person that likes to be in front of a camera and have myself recorded. So this is going to be quite a learning experience for me. I want to welcome my guest today, Marilyn Monahan of Monahan Law Office. And we're going to be talking about the celebration of ERISA's 50th birthday or 50th anniversary, depending on who you are and what you prefer to use, I guess. Welcome, Marilyn, and thanks for being with me today and being my first podcast guest for our first video podcast.
Well, it's a pleasure being here with you today, Dorothy, for two reasons. One, your first video podcast guest, as well as ERISA's 50th birthday, which is quite a milestone birthday for ERISA and a good time for us to spend some time talking about what it's all about.
So this has been like the longest birthday celebration I've ever experienced for the entire calendar year of 2024. But I have to admit, it's been fun doing that, especially with you. And you made a very special occasion of it. You actually made a 50th birthday cake for ERISA. Would you mind sharing?
I did. And here it is, ERISA's 50th birthday cake.
Yeah, it's so cute.
Which I've been bringing to presentations and to conference exhibit booths and the like for the last few months.
Yeah, it's been, as I said, I've been with you on many of those occasions where you've shared your cake. Unfortunately, you can't eat it because it's not a real cake. But what I've been doing at our lunch and learns and so forth is I've actually been ordering a cake, like a quarter sheet cake or whatever, of ERISA's 50th birthday. So in addition to your cake, which is beautiful that you take everywhere, I've actually had one we could eat when we were in person doing events. So everybody kind of likes that because it's fun, you know. But anyway, this is kind of a different type of podcast for us because you and I usually do very, very difficult topics, very, compliance related, legal issues, that sort of thing, regulatory issues. But I wanted to do this one on a little bit lighter side. Is that okay with you?
Absolutely. And, most people do not connect ERISA and fun, but I think let's connect ERISA and interesting. Let's do it that way, because I think it is interesting why the law came about and what it's attempting to do. And I think if people understand that, they'll understand a little bit better why they have all these compliance obligations. There really is a point to it, even if they feel annoying or burdensome at times.
Yeah. And I agree with that because you're right. It's usually not a very exciting topic, unfortunately. Yeah, but we get used to that. People say stuff, that's not fun. That's ERISA. That's legal. That's regulatory. That's horrible. Anyway, so let's talk about ERISA, which you and I have done many, many times before. Let's look back at the history of ERISA. It was signed into law by President Gerald Ford on September 2nd, 1974. Some of our audience probably wasn't even born yet at that time. First of all, let's start off with the basics. What does ERISA stand for? And what was the motivation behind signing this bill into law?
Well, ERISA stands for the Employee Retirement Income Security Act of 1974, which is a bit of a mouthful, so they call it by the acronym ERISA. And when ERISA was first enacted, the real focus of it was on pension plans. It applied to both health and welfare and pension plans, but it was particularly focused on pension plans because there had been a lot of press over the last few years about some problems that had occurred with regard to the administration and viability of pension plans. And they wanted to address the problems that the public and Congress perceived to exist in the industry at that time.
Yeah. So, there's an industry and a government joke that ERISA stood for every ridiculous idea since Adam. And also that it was the actuaries, accountants, and attorneys' full employment act. Do you agree?
Well, I get where that comes from, but I think it's not in my best interest to necessarily agree with that. I do understand the frustrations that employers sometimes feel when they're trying to grapple with all the complexities and the compliance challenges that ERISA creates. But I have to confess that you won't find me using those names for ERISA because I do think they distract from all the good things that ERISA does and all that it has accomplished.
Yeah, for sure. Well, why was Congress so focused at first on pension plans?
Well, there had apparently been many reports in the press concerning pension plans and employees not receiving the benefits they thought they were due. One case that generated a lot of attention involved a Studebaker plant in South Bend, Indiana, which closed in 1963. Apparently, the pension plan was seriously underfunded, perhaps by as much as $15 million. As a result, employees under 60 who lost their jobs also, when it came time to collect their pension benefits, they only received 15 cents on the dollar, even though many of them had worked for Studebaker for decades. With regard to employees who had less than 10 years of service, they received nothing. And that impacted 2,900 employees. So the Studebaker situation got a lot of press. It raised a lot of concerns. People thought reforms were needed. Another issue that kept happening in the pension world, or I shouldn't say it kept happening, but another issue that was coming up in the pension world had to do with vesting. And you had stories where people would work for years, but they might have had one short break in service. And as a result of that, they were losing their vested right to benefits. So they felt reform was necessary. They felt transparency was necessary. They felt they needed more protections to ensure the viability of benefits so that when employees needed the benefits, whether pension or health and welfare, they were there for them.
Yes, thank you for that. The timing of the law, I think, in history was actually quite interesting. Is it true that it was signed into law the summer that President Nixon resigned? I believe he resigned August 8th, 1974. And an attorney for the Department of Labor wrote that the pressure was intense on the staff that was writing the legislation and that they wanted to get a bill before the House before it was expected to take up the impeachment proceedings for President Nixon. I guess they didn't expect him to resign at that point. So how big and how important was the signing of the law at this particular time?
Well, I wasn't really focused on ERISA in the summer of 74, but I do understand that there was a lot going on that summer. It was a very dynamic situation. They weren't certain what President Nixon was going to do. And ultimately, they didn't have to bring impeachment proceedings because he did resign on August 8th. But apparently, throughout the summer, they thought that impeachment proceedings might be the next step. When he did resign on August 8th, I think that there was a feeling between President Ford and Congress that they wanted to sign something. They wanted to put in place some legislation that was a unifying act that all the country could come together on and agree, we need to make some changes. We need some improvements here. And ERISA was one step in that direction. So President Nixon resigned on August 8th and President Ford signed ERISA on September 2nd. So less than a month later.
Well, ERISA is supposed to preempt state laws related to any employee benefit plan. Can you talk about that a bit and tell our audience what that means, really?
The drafters wanted to avoid state-by-state regulation of plans subject to ERISA. The preemption provision is intended to make Congress and not the states the final word on the regulation of plans governed by ERISA, whether they're pension plans or health and welfare plans. The benefit to that structure for employers is that they only have to follow one set of rules, not 50 sets of rules. This is particularly advantageous to multi-state employers.
Yeah, for sure. And I understand that ERISA passed with overwhelming support and that it was believed that it was looked at, as you said, as an act of national unity by the president and the Congress. And I believe the vote was, if my research was correct, 402 to 2, which is pretty overwhelming in the House, and 85-0 in the Senate. What are your thoughts on this as an ERISA attorney?
Well, Congress, the president, and the country saw a need and worked together to address it. People wanted to make certain that benefits were there for people when they needed them, and they worked together to develop a system to make sure that happened.
Yeah, and this law has had a profound impact on insurance and the benefits industry, of course. As you know, I always call it ERISA is the plan sponsor's Bible. Let's talk first about pension plans. Why was ERISA so important in protecting pension plans? You've already touched on that, but let's get into a little bit more.
Well, we have touched on that. And you can see, if you know ERISA, how the stories people were hearing about, such as Studebaker's allegedly underfunded plan, and that employees at that company weren't going to get the benefits they expected. And you can see how those situations were actually addressed by specific provisions in ERISA. So, for example, they have reporting requirements in ERISA, the Form 5500, which is a way to track the financial stability of the plan. They have disclosure requirements in ERISA so that participants and beneficiaries know the terms and conditions under which benefits will be available to them, both the plan's obligations and the participants' obligations, what they have to do to make sure their benefits are there. Another thing ERISA did was it created the Pension Benefit Guarantee Corporation, the PBGC, which protects participants in the event that their plan goes insolvent.
Well, thank you for that. We've talked about the fact that the original focus of ERISA was on protecting pension plans, but it also applies to and provides protections for health and welfare benefits, which you and I work with a lot, obviously. Can you talk about that a little bit for us?
Well, many of ERISA's provisions, such as the reporting and disclosure requirements that I just alluded to, apply with equal force to both pension and health and welfare plans. And although the original focus of ERISA was on pension plans, many of the same rights, duties, and protections applicable to pension plans also apply to health and welfare plans and benefit participants in those plans. Since ERISA's enactment, the impact of the law on health and welfare plans has been even more pronounced through various amendments to ERISA. The passage of COBRA in 1985, HIPAA in 1996, the Affordable Care Act in 2010, and the Consolidated Appropriations Act of 2021, which was actually signed in 2020, have all had a profound impact on the administration of health plans, the scope of benefits offered through those plans, as well as participant protections.
Well, thank you. Overall, what do you think ERISA has impacted most?
When ERISA was first passed, I suspect people would have said the new level of transparency that was created with the reporting and disclosure requirements. Since then, with regard to health and welfare plans in particular, I suppose the biggest impact has come through the amendments to the law that have impacted the scope of coverage, such as the Affordable Care Act, and those that have expanded patient protections, such as HIPAA and the No Surprises Act, which was part of the CAA, and placed limits on balance billing.
Well, let's talk about the importance of ERISA for union plans and self-funded plans. Let's start with union plans. How has ERISA really helped them?
Well, from my perspective, I would say ERISA has created a uniform standard across the country for benefit plans that the parties to the collective bargaining process can recognize and rely upon in their negotiations. From that, they can then move on and focus in their negotiations on other things that are of concern to union members as well as to management, such as developing benefit options and the cost of coverage.
So what about self-funded plans? As you know, that's my specialty as an insurance agent and a benefits consultant and professional. Why is ERISA so important in protecting self-funded health plans, both in the past and in the future?
Well, although ERISA created more regulatory obligations for plan administrators, and there are more administrative hoops they now have to jump through, and that has expanded with the amendments to ERISA, such as COBRA, HIPAA, and the ACA, it also gives employers a certain amount of flexibility in some respects. When an employer offers a fully insured health plan, that fully insured health plan remains subject to state insurance laws, including state insurance coverage mandates. That happened because Congress made an exception to the ERISA's preemption provision when it passed the original law to accept state insurance laws. So what that means is that if the employer has a self-funded plan, the state insurance laws do not apply because the plan is not fully insured. This gives the self-funded employer more flexibility over plan design because such an employer only has to focus on federal law and not multiple state laws.
Yes, and we see that as a huge benefit every single day in the self-insurance industry. So speaking of that, the industry in itself, I am a member of the Self-Insurance Institute of America and have been for decades. And I bring that up because associations like that follow all the attempts at dismantling or weakening ERISA, because that's always coming at the law from many different sides at many different times, many different ways. How important is that associations, employer plan sponsors, agents, consultants, all of these people in this community stay vigilant in trying to preserve and protect ERISA?
Well, I will address those questions generally. It is important, whether you are an employer, a broker, a consultant, or an attorney, to stay informed and engaged. We just had 2 new significant developments announced this morning with regard to employee benefit plans. The laws passed by Congress amending ERISA can have a profound impact on the administrative requirements that apply to employer-sponsored plans, as well as the scope of benefits included in those plans. All concerned parties need to be aware of upcoming changes and have a voice, where possible, in the process of the creation and implementation of laws and regulations related to their benefit plans.
You mentioned that there were 2 announcements just recently, including this morning. Why don't you just briefly tell our audience what those 2 items were?
Well, the 2 items I had in mind were the affordability percentage under the Affordable Care Act. That was announced this morning. That's the affordability percentage that will apply in 2025 when employers are making the decision as to how much to ask employees to contribute toward the cost of coverage. And the other big development was a new set of mental health parity regulations. We have been waiting for these for quite a while now, and they were just issued this morning. And that's going to potentially impact the scope of benefits that employers are currently offering, as well as the administrative hurdles that they have to jump over in order to satisfy the new rules and regulations.
Well, thank you for that information, and you and I will be diving into that.
We will be.
We're going to be covering that in our legal updates presentation, our Lunch and Learn this October, and then talking about it in more detail as more information becomes available. So stay tuned to the Benefits Executive Roundtable. I'm sure we'll be putting excerpts from those webinars and Lunch and Learns in person on the Benefits Executive Roundtable podcast. So let's talk about ERISA oversight in Washington. ERISA has more than one government entity that's involved with compliance and enforcement. Can you tell us what branches of government are involved and to what end?
Well, first, the United States Department of Labor, and within the United States Department of Labor, the Employee Benefit Security Administration, or EBSA, has primary responsibility for reporting, disclosure, and fiduciary requirements. So they're going to be the entity that is most focused on enforcing those sections of ERISA. The Treasury Department, and more specifically the IRS within the Treasury Department, has primary responsibility for participation, vesting, and funding issues. But there is overlap between the 2, and the Department of Labor, for example, will get involved in some areas where the IRS would traditionally become involved or traditionally have primary enforcement authority. So the 2 entities do talk, and they do have some overlapping responsibilities. Some of the many amendments to ERISA, such as the Affordable Care Act and the CAA, also included provisions that fall within the jurisdiction of the Department of Health and Human Services, HHS, and the agency within HHS that is responsible for that is the Centers for Medicare and Medicaid Services, or CMS. So you have a number of different departments who have some enforcement authority with regard to ERISA and the various amendments to ERISA that have passed over the years.
Well, ERISA's been amended many, many times, as you said. Can you tell our audience some of the most important recent amendments and additional laws that impact ERISA? And I know you've talked about some of them already.
Well, I think it'd be hard to choose a most important. Maybe that's like choosing your favorite child, which no parent can do. But obviously...
Some can. Oh, sorry.
So that's true. Obviously, COBRA, which passed in 1985, was a game changer for those individuals who lose group health plan coverage as a result of a job loss or certain other circumstances that results in a loss of coverage. I suppose I would say that the greatest impact on health plans generally, and thus on those who are in plans subject to ERISA, would have to be the Affordable Care Act. The ACA has had a tremendous impact on all aspects of the health plan world, fully insured, self-funded, individual plans, small group, large group, etc. It too was a real game changer, even with much more far-reaching changes than COBRA.
Yeah, thank you for that. And in addition to the amendments to the law, the departments change or update their focus from time to time. One example, of course, is the relatively recent guidance by the Department of Labor on cybersecurity and benefit plans, which kind of surprised a lot of people when they actually stepped up and made that part of their jurisdiction, so to speak. Can you briefly tell our audience about the 3 sets of cybersecurity guidance that were released by the department in 2021 and why it's so important, and also the very, very recent, just last week, of the updates to those guidances?
Yeah, we talked about the guidance that came out this morning. There was other guidance that came out last week. It's a full employment act for both of us. The history behind this is that back in 2021, the Government Accountability Office issued a report on cybersecurity standards and retirement plans. And they asked the Department of Labor to respond to the report issued by the GAO. And one way that the department responded back in 2021 was to issue 3 guidance documents on the importance of having strong cybersecurity standards at the employer level, but also to make certain that any service providers that the employer hires to assist with the administration of their benefit plans also have strong cybersecurity practices in place. And apparently there was some confusion when that guidance first came out, and some people thought it only applied to pension plans and it didn't apply to health and welfare plans. The Department of Labor has since clarified that, and they've stated no, the obligation to have good, strong cybersecurity practices and policies in place is part of a plan fiduciary's functions under both the duty of loyalty and the duty of prudence. It's also consistent with the record retention rules under ERISA. So the bottom line is having good cybersecurity practices and making sure your service providers have good cybersecurity practices is an obligation, a fiduciary obligation under ERISA. And to clarify that it applies both to retirement plans and health and welfare plans, they updated their guidance, those 3 guidance documents I mentioned just last week, and issued an updated set where it clarifies that point and makes a few other amendments and tweaks to their original guidance documents.
Yeah, and it was good timing of them to do that because you and I are actually having a webinar on that this week, and we'll be talking more about that, and again in October with our legal compliance lunch and learn. So anyway, lots of good information there and lots of good updates. Yeah. Well, you and I are doing a 2-hour webinar actually later this month for Advanced Benefit Consulting on ERISA fiduciary responsibilities, and we're going to get into the details of ERISA compliance here, get really into the details. And we'll be sharing some of the excerpts from that particular webinar later on in the season of the Benefits Executive Roundtable, as I said. Keeping it simple for this particular podcast episode, what does it mean to be a fiduciary under an ERISA plan, and why is that so important?
ERISA requires every group health plan to have a named fiduciary, and that means in their plan document, they must specifically identify an individual or a group or an entity as the plan fiduciary. In addition, there are individuals or entities who could become fiduciaries because of the level of services they provide. It is important to identify the plan's fiduciaries and to understand their duties under ERISA, because a breach of fiduciary duty could result in damages to the plan, to plan participants, to plan beneficiaries, and also could result in an audit by the Department of Labor, the IRS, or ultimately perhaps even, and unfortunately, a lawsuit for breach of fiduciary duty. And there is increased focus on fiduciary standards and whether or not fiduciaries are satisfying their obligations under ERISA in the administration of health plans. There has been some increased litigation over these concepts in the last year.
Yeah, and as I say all the time, as you are aware, if it looks like a duck, it acts like a duck, it sounds like a duck, it's a duck. So I just want to caution people that sometimes people say, I'm not a fiduciary. But if what you're doing, the functions that you are performing are those functions of a fiduciary, then you will be named a fiduciary, whether you were wanting that to happen or not. And I think that's important for people to understand.
I think that's true. Yes.
Yeah.
Particularly service providers, but also some people within the employer's workforce who may not realize that they are stepping over the line and have taken on fiduciary responsibilities and therefore have become a fiduciary.
Right, exactly. Well, ERISA requires that plan fiduciaries use the prudent man or the prudent person standard, as they now call it, to be politically correct. Can you explain what that means to our audience?
Well, I'm going to actually quote from the statute itself because it explains what that means. So under ERISA, when administering the plan, the fiduciary must act with the care, skill, prudence, and diligence under circumstances then prevailing that a prudent person acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character with the same aims. As interpreted by the courts, this is actually a prudent expert standard. So although they call it a prudent person, it's really a prudent expert standard. And some case law has even stated that a fiduciary's duties under ERISA are the highest known to the law.
Well, thank you for that. Let's talk about the primary disclosure requirements for health and welfare plans under ERISA, just in brief for our audience, if you don't mind.
When they say disclosure requirements, what they're really talking about is documentation requirements. And that's true whether or not you're producing pieces of paper or you're producing them electronically, as so many employers do now. So these are the legal documents that establish the plan, set out the terms and conditions on which the plans will operate, as well as the terms and conditions under which benefits will be paid. They not only describe what the plan has promised in benefits and is legally obligated to provide because they've made those promises, but also what participants and beneficiaries are required to do in order to obtain the benefits, because there are some obligations on participants and beneficiaries as well. They place participants and beneficiaries on notice of their rights and responsibilities. The primary disclosure requirements are the plan document, the summary plan description, also referred to as the SPD, which is not the same as the plan document, the summary of benefits and coverage, which is also referred to as the SBC, and then various notices that must be provided either annually or included within the plan documentation. The SPD, the SBC, and the notices must be distributed to plan participants, typically at open enrollment.
Right. And there are some exceptions to that, of course, but you're right, typically at open enrollment. There's a lot there to unpack. People are going, what? I thought this was not supposed to be very detailed. But we'll get into more of that, as I said, in a future 2-part episode of the Benefits Executive Roundtable. Today, we just wanted to share with you, as our audience, why the 50th birthday or anniversary of ERISA is so important to the employee benefits world in general. So thank you very much for doing that.
I want to once again wish ERISA a very happy 50th birthday. And I want to thank you, Dorothy, as well as to all the people who are taking an interest in ERISA during this milestone year for the law.
Yes, thank you very much. And if anyone should want to reach out to you with questions, comments, anything like that, how would they do that?
Well, my email address is marilyn@monahanlawoffice.com.
And that's the best way to get a hold of you all the time. I can say you're very good about responding to emails. I can say that for sure. Well, thanks again, Marilyn. I really appreciate your sharing your insights on ERISA. This was a lot of fun. Thank you very much for doing this.
Thank you all for joining us. And Dorothy, it's always fun talking about these compliance topics. I definitely enjoyed the back and forth. And to everyone listening in, we appreciate your interest in this very important topic.
Oh, thank you very much for that. And they're not only listening in this season, but they're also watching us, which is kind of cool. But to everyone out there, both long-term and newer audience members, I want to thank you very much for joining us for this episode of the Benefits Executive Roundtable. Please stay safe, stay healthy, and stay tuned for the next episode of the Benefits Executive Roundtable. Thanks, everyone.
Thanks for watching. Stay tuned for compliance tips, cost containment ideas, new trends, and decision-making tools. This podcast is produced by Advanced Benefit Consulting, Anaheim, California. All views expressed are those of the host or interviewees and not necessarily the views of Advanced Benefit Consulting. Information contained herein should not be construed as legal advice. We always recommend that you consult with your legal counsel as situations do vary. Ms. Cociu can be reached at 714-693-9754 extension 3 or toll free at 866-658-3835. By email at dmcociu@advancedbenefitconsulting.com or visit our website at advancedbenefitconsulting.com.